For the record, I am the flesh and breathing man.
All right. Well, I'm glad you're breathing. So,
For the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion. I need to know the jurisdiction this court is operating under.
so have a seat. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat.
If I don't come here, warrants will be placed, which I will be kidnapped and held hostage, and I do not want that.
Mr. Casanova, in the human flesh, I'm going to stop you right there. And I want you to hear me clearly.
All right, everyone. Today we got another sovereign citizen taking on Judge Boyd, but this case is a little different. Instead of responding with frustration or immediately shutting him down, Judge Boyd uses a completely unexpected strategy: patience, respect, and relentless kindness. At first glance, it seems like she's giving him more room to talk, but in reality, she's carefully controlling the entire courtroom while allowing him to expose the flaws in his own arguments. It's a fascinating approach to watch unfold because she's playing several moves ahead while he's convinced he's in control. As the hearing progresses, you'll see why this strategy is so effective. Rather than getting dragged into pointless debates, Judge Boyd calmly keeps the focus on the law, dismantling each sovereign citizen claim without raising her voice or losing her composure. It's a masterclass in courtroom control and judicial patience. Watch closely and let me know in the comments whether you think this calm, methodical approach is more effective than the tougher judges we've covered before. With that said,
How's it going?
It'll be better.
All right. So my understanding, you want to represent yourself? All right. You're more than welcome to represent yourself. But here's the thing. Everybody says that they can be an attorney because all attorneys do is talk. That's what people think. But they don't realize there's a lot of knowledge, experience, and wisdom behind that.
Absolutely.
So if you want to have a jury trial where you represent yourself, you're more than welcome to do so. But once it's set for trial, it's going to trial, and no one's going to be helping you. The state is not going to say, hey, we see that you really don't know the rules, so let me tell you this rule. They're not going to be doing that. My job is not going to be to help you with objections, help you with motions. That's 100% you. Do you understand?
I do. And are we on the record?
No, we're not on the record. What, you want to put something on the record?
Oh, yes, definitely.
Sure. All right, court is calling 2024 CR 2974, State of Texas Vector versus Hector Casanova. Can I have parties announced for the record for the state? And are you Hector Casanova?
No, for the record, I am the flesh and breathing man. I'm here on a special appearance to clarify any misunderstanding. I am not the legal fiction known as Hector J. Casanova that is on the information there. I just have a few questions to clarify some things.
All right, so if you would like to clarify some things, then the person I need to speak to is the flesh and blood man known as Hector Casanova.
Yes, I'm the flesh and blood man, Hector Casanova Jr.
All right, so you are Hector Casanova, correct?
I am Hector Casanova Jr., the flesh and breathing man.
All right, well, I'm glad you're breathing. So what did you want to place on the record?
Well, first, I don't understand the charges that are being brought against me.
Mhm.
There are some clarifications I do want to.
All right, so just 1 second, but before we get to that, have you been given a copy of the indictment?
No, I have not.
All right, so we're going to get you a copy of the indictment. Just give me a moment. All right, have a seat. We're going to come back on the record with this.
All right.
So we're back on the record in 2024 CR 2974, State Vex versus Hector Casanova. All right, Mr. Casanova, here's the thing. And I want you to hear me clearly, right? I am not your attorney. The document that has been given you is a copy of the indictment. I'm not to give you information about your indictment. That's the indictment. That's what we're here for.
Right.
So any questions that you would have about that indictment, you're going to have to answer those for yourself. Otherwise, the person who will be telling you about what the indictment means and what the numbers are, that will be an attorney. Do you understand?
I do not understand.
oh, you don't understand? All right then. Maybe we should just order a competency evaluation. At this point, it almost feels like we need a better way to handle these sovereign citizen arguments before they ever make it into a courtroom. Cases like this can consume a tremendous amount of court time, even when the legal issues have already been settled by established law. It's easy to see why judges are often forced to spend valuable time addressing claims that have repeatedly been rejected by the courts. One thing worth remembering is that representing yourself in court is a legal right, but it's also a serious responsibility. Success requires understanding courtroom procedure, the rules of evidence, and the law itself. Simply declaring that the court has no authority or insisting that the laws don't apply to you has consistently failed in courtrooms across the country. Those arguments don't change the court's jurisdiction, and they don't prevent a judge from issuing legally binding rulings. That's what makes Judge Boyd's approach so interesting. Instead of arguing emotionally or escalating the confrontation, she patiently lets the legal process speak for itself. She stays focused on the facts, applies the law, and methodically addresses each claim without getting sidetracked. In the end, it's another reminder that confidence alone.
Oh, what that means is, for example, we can go off the record. I'm giving you a hypothetical. All right. Let's say you needed surgery and you're in the middle of the wilderness. You need surgery. And you tell me and you tell the doctor, guess what? I'm performing this surgery on my own. I don't need you. I'm walking out of the hospital. I'm going to go in the desert. Now, maybe the doctor would try to stop you and do other things. But if you go in that desert by yourself, don't tell the doctor where you are. You take a scalpel out in the desert by yourself. You don't get to call the doctor and say, hey, I'm in the middle of the desert performing surgery. I'm going to be my own anesthesiologist. I'm doing all of this. How do you do this? Because they're not going to tell you. It's the same thing here. You're saying that you do not want to be represented by an attorney. You want to represent yourself. So that motion, that indictment, I'm not to tell you anything about what that indictment is. The state is not to tell you, oh, this is what this indictment means. This is the range of punishment. Those are things that you're supposed to do. Do you understand?
I still don't understand.
All right. So just have a seat. This is what's going to end up happening. You're going to have an attorney. That attorney is going to come over to the court right now. You're going to speak to that attorney. After you speak to that attorney, we're going to go forward. Ms. Ferguson, can you call manage to sign counsel and let them know that we need an attorney over here? And that attorney will talk to you. That attorney will tell you what that indictment means. That attorney will tell you the range of punishment. Do you understand?
I still don't understand.
All right. Well, I don't know how I can further make you understand.
Are we on the record?
Yeah. All right. Norma, get someone from manage to sign counsel here, please. All right. Just have a seat and we're going to have an attorney come down. All right.
I would like to ask some questions on the record, if I may, while I have your time here.
Oh, no. Let me just tell you, you'll have my time till 5 o'clock because that's how long we're here. What is going to end up happening is an attorney from manage to sign counsel is going to come down. Do you understand?
I do not understand because I don't feel like I am needing an attorney because I'm here to represent myself as the flesh and breathing man, Hector Casanova Jr. Let's see. All right. So let the record of the court show that I, Hector Casanova
Just one
Jr.
second.
The
We're
accused
just
in
one
the
stop.
Yes, sir.
All right, we're on the record. So what did you want the record to reflect?
So let the record of the court show that I, Hector Casanova Jr., the accused in this criminal action, has asked the court to divulge the nature and cause of the accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action.
This guy just keeps digging himself into a deeper hole with every word he says. The judge has already explained in clear and straightforward terms exactly what he's being charged with, yet he continues acting as though he has no idea what's happening. Instead of addressing the issues before the court, he keeps falling back on the same arguments, hoping they'll somehow change the outcome. But the more he talks, the clearer it becomes that those tactics simply aren't working. What really stands out is how calm Judge Boyd remains throughout the exchange. She repeatedly gives him opportunities to listen, respond appropriately, and participate in the proceedings, but he seems more focused on following his own script and engaging with the actual legal process. At a certain point, refusing to acknowledge the court's explanations doesn't strengthen your position. It only makes your arguments less credible. It's also important to remember that honesty in court matters. Making false statements under oath can have serious legal consequences, including potential perjury charges. Although whether that applies in any particular case depends on specific facts and the prosecutor's decisions. Either way, the judge has made the situation abundantly clear, and continuing to deny or misrepresent what's already been established is unlikely to help his case. From where things stand, this is becoming less a legal defense and more of a demonstration of why sovereign citizen arguments.
Furthermore,
let me
let the
stop
record
you.
also show.
Mr. Casanova, let me ask you a question. Have you been given a copy of the indictment?
I believe so, yeah.
All right, so let the record reflect that Mr. Casanova has been given the copy of the indictment, and the copy of the indictment, it tells him what he is charged with. You may continue.
Now, these charges, are they civil? Is this a civil charge or a criminal charge?
All right, that is something that if you had an attorney to represent you, they would be able to tell you. What the court can tell you is that you are in a felony court and this is a criminal court.
Okay. So, this being a criminal, let the record of the court show that the action against me is criminal action. My following question would be, the Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under the admiralty or military tribunal. In which of these two jurisdictions does this court intend to try me?
All right, so this is what is going to happen, Mr. Casanova. Someone from Managed Assigned Counsel is going to come over and you can speak with them or not speak with them. But the questions that you are asking the court are not, some of them are not in any shape, form, or fashion related to the fact that you're in a criminal district court. Do you understand?
I do not understand.
Okay.
But I don't think you'll be violating your oath of office if you did your duty under the Constitution. I am not seeking legal advice. What I want to know is legal intent.
Mhm.
I have the right to appear as myself in my own person without a licensed attorney. In order to intelligently defend myself, I need to know the jurisdiction this court is operating under.
Mhm.
Let's see. So therefore, will you please answer the question so that way this court is.
District court, it's a criminal court. You're on the 4th floor.
Thank you. This Constitution grants this court two types of criminal jurisdiction. Criminal jurisdiction under the common law and criminal jurisdiction under
All right, I'm
admiralty
going
or
to
military
counsel.
tribunal.
I'm sorry, Mr. Casanova, in the human flesh. I'm going to stop you right there. What is going to end up happening, I want you to hear me clearly. An attorney is coming over for Managed Assigned Counsel, period. That's it. So have a seat. Managed Assigned Counsel will come over. Do you understand? Yes or no?
I do not understand.
All right. Do you understand what it means to take a seat?
I do understand.
All right. So take a seat.
Yes, ma'am.
Thank you.
Of course.
Usually I hate
One thing I've noticed is that different judges have very different courtroom styles, and not every approach is equally effective in every case. While some judges take a much more forceful approach, Judge Boyd chooses to stay calm, patient, and firmly in control. And in this hearing, that strategy seems to be working remarkably well. Rather than getting drawn into emotional back-and-forth exchanges, she carefully listens to each response, addresses the relevant legal issues, and keeps the proceedings moving forward. You can tell she's thinking several steps ahead, making deliberate decisions instead of reacting impulsively. That steady, methodical approach leaves very little room for distractions or arguments that don't have any legal merit. Meanwhile, the defendant appears convinced that his arguments are giving him the upper hand, but the courtroom tells a very different story. As the hearing continues, Judge Boyd maintains control of the process while allowing him every opportunity to present his position. In doing so, she demonstrates why patience, preparation, and a thorough understanding of the law can be far more effective than raising your voice or escalating the confrontation. What do you think? Is Judge Boyd's calm, measured approach the best way to deal with cases like this? Or do you think judges should take a firmer stance from the very beginning? Let me know your thoughts in the comments. Now, let's dive back into the hearing and see what happens next.
Informed him that I'm here, to help him in whatever he needs help with. He's going to consider what help he thinks he might need from me, and I know he wants to put something on the record.
Okay. All right. And so you'll be appointed as standby
Yes.
counsel then?
I've kind of explained my role and what that means and how I can help him with something as simple as e-filing or that type of thing. So.
All right. We're going to go back on the record in 2024 CR 2974, State versus Hector Casanova. Mr. Casanova, if you'll come forward. Yes. All right. So, Mr. Casanova, Mr. Bonk is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right.
Uh,
And he informed me you wanted to place something on the record?
yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right. Who threatened or coerced you to come to court?
The county of Bear, Texas.
How
State.
so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date, and you can accept the state's offer or come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date, and then you'll sign it. Mr. Bonk will sign it to signify when you're to come back. All right.
I appreciate your time.
All right, you're welcome, and thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing to
You'll
come
need-
up ahead of time?
You'll need to speak to the court coordinator, and they will let you know. I will tell you the rescheduling of cases. Are you in the hospital? You're not in the hospital, you need to be here.
Okay,
You understand?
so pretty much no excuse, be here.
Yes. All right, thank you.
Thank you.
I have to admit, this was one of the more unusual courtroom exchanges we've covered. The defendant seemed surprisingly relaxed throughout the hearing, even after the judge repeatedly explained the seriousness of the situation. It's difficult to know exactly what someone is thinking based solely on their demeanor, but from the outside, he appeared far more confident than the circumstances seemed to justify. When he asked about moving the court date, it raised questions about his overall strategy. There can be legitimate reasons to request a continuance, so it's impossible to know his intentions without more information. What is clear, though, is that delaying a case or relying on arguments that have consistently failed in court is rarely an effective legal strategy. Ultimately, the court will continue to move the case forward according to the law and established procedures. The biggest takeaway from this hearing wasn't the defendant's behavior. It was Judge Boyd's approach. Throughout the proceedings, she remained calm, respectful, and firmly in control. She gave the defendant every reasonable opportunity to understand the process, explain his position, and participate appropriately, all while keeping the hearing focused on the law instead of the distractions. Rather than escalating the situation, she demonstrated how patience, professionalism, and a clear understanding of courtroom procedure can often be the most effective way to handle difficult cases. Overall, I thought Judge Boyd did an excellent job managing this hearing. She never seemed rattled. She stayed focused on the facts, and she handled the proceedings with confidence from start to finish. Whether you agree with every decision or not, it's hard to argue that she wasn't in control of her courtroom the entire time. Now I'd love to hear what you think. Did Judge Boyd handle this case the right way, or would you have preferred a different approach? Let me know your thoughts in the comments. I genuinely enjoy reading your perspectives and seeing the discussions they spark. If you enjoyed this breakdown and want to see more courtroom analysis like this, don't forget to leave a like and subscribe. I upload new videos regularly, so there's always more content on the way. Thank you so much for watching. I truly appreciate your support, and I hope you're all doing well. Until next time, take care